Welcome back to In Focus. The Department of Justice announced on Tuesday that they have filed a lawsuit challenging Idaho's ban on abortions, a near total abortion ban. The law is set to take effect on August 25th. Like I said, it would ban all abortions except for cases of incest or rape that are reported to law enforcement, or when a physician somehow determines that an abortion was necessary or could be necessary to save the life of a pregnant woman. But the DOJ is arguing that this ban would criminalize doctors for performing abortions during medical emergencies. Attorney General Merrick Garland discusses more about this yesterday. Here's what he said.
Today, the Justice Department filed a lawsuit against the state of Idaho. The suit seeks to hold invalid the state's criminal prohibition on providing abortions as applied to women who are suffering medical emergencies. Under a federal law known as the Emergency Medical Treatment and Labor Act, or EMTALA, every hospital that receives Medicare funds must provide necessary stabilizing treatment to a patient who arrives at an emergency room suffering from a medical condition that could place their life or health in serious jeopardy. In some circumstances, the medical treatment necessary to stabilize the patient's condition is abortion.
Criminal defense attorney Bob Bianchi joins me now with a legal perspective on all of this. Bob, thank you for joining the program. I appreciate it. So it would seem to me, I'll let you lay out the legal case for this, but it would seem to me that if anything, when AG Garland says this is not in any way going around the Supreme Court, I think at least in some ways it is to try to demean or belittle the decision that was handed down on Roe and Dobbs, when you consider that, you know, the basic argument is that states have a right to make their own laws surrounding abortion, and now they're doing everything in their power to go after states who are making their own abortion laws. But you're the lawyer here, so I'll let you lay out the merit for this lawsuit from the Department of Justice, if there is any.
Yeah, well, the devil's in the details of the United States Constitution, Addison. Interestingly, the Founding Fathers had a very big debate when they were forming this country as to what happens if a state law is passed that contradicts or contravenes a federal law. And there was a lot of debate that went back and forth. There was the Virginia plan, and there were a lot of people that were arguing. Ultimately, they came to a conclusion of something that's in Article 6, Paragraph 2 of our Constitution called the Supremacy Clause. Now, this is not a political thing. It's a legal issue. And the Supremacy Clause was basically saying that if there is a federal law where the Congress has passed, the representatives of the people essentially have passed a law that is contradictory, or a state law is passed that's contradictory to the federal law, then the federal law preempts or supersedes the state law. And that was in order that we didn't have a whole bunch of disparate states doing different things, and we couldn't have a uniform national government. So what Garland is interestingly doing here is, again, on the right and on the left of it politically, I don't care. What the Supreme Court did, in my opinion, was kind of a narrow, in Dobbs, a narrow thing. They basically said there is no federal right to an abortion in the Constitution. So the Roe is reversed because Roe created a federal right in the Constitution that the new Supreme Court Justice said in Dobbs does not exist. Therefore, they said in Dobbs, the rights of abortion or not reside with the states, and each individual state can make its own laws. What Garland is interestingly doing is going now to the Supremacy Clause, and that I mentioned before, that says no state law can trump or overcome a federal law. And they're saying that there's this law that says you must provide services that are necessary for the safety of the patient, not just death, but for the medical safety of the patient. So if you take federal money, all abortions are lawful and that you can go to the hospital and have them, just in this narrow exception when you don't have to wait to the moment of death before you perform an abortion. It can be for serious medical conditions. That's what Garland's going to argue.
So is there any argument then that, you know, with Roe and Dobbs being overturned, the Supreme Court justices, the highest court in the land, saying that there is no federal right enshrined in the Constitution, like you said, for abortion, wouldn't then those other federal laws that make exceptions for abortion, or that have any other federal laws for abortion, wouldn't those come into question in light of the Supreme Court's decision?
I think in every instance where you see there is a law passed by Congress, again, going to the Supremacy Clause, a state cannot preempt or do a law that is in contradiction to a federal law. So every single instance in which there is a current federal law, I don't think there's going to be a lot of them. I mean, this is one of them, where it says that basically here's the federal law and the state does something that is contrary to that federal law, then I think you're going to see a lawsuit in all of those jurisdictions where they're trying to limit access to abortion.
If the federal law, so if there was a federal protection for abortion in case of rape or incest, right? So it's not for all abortions, but in the case of rape and incest, if there is that federal law, but then the Supreme Court comes along and says, you know, when Roe and Dobbs were decided, it was illegitimate, it was incorrectly decided, abortion should have never been a federal issue from the start. We are now sending this back to the states. So wouldn't that Supreme Court declaration, that Supreme Court striking down that, wouldn't that delegitimize the federal laws on abortion? Because the whole point of overturning Roe and Dobbs was to get the federal government out of the abortion issue.
You know, you bring up such an interesting point, Addison, and again, not to get into politics of it, but many times there have been arguments that the previous Supreme Court that was more liberal was legislating from the bench, that they are lifetime appointees, they weren't elected to pass laws. That was a major argument in this Supreme Court decision with Dobbs, that the Supreme Court previously under Roe was making law that is in the province of the Congress, not of the court. So I don't think that the court can now say, you know, listen, we overturned Roe for this, but now we're going to say that abortion bans that states have that we don't like, we're going to agree with or disagree with. They're basically saying, no, that's up to Congress and the states. So if Congress were to pass a law, for example, which is not likely in today's political environment, but they were passed a law that said all abortions are allowable, it would be unlikely the Supreme Court would reverse that, because they're not saying that it comes from the Constitution, an interpretation of the privacy clause of the Constitution. Now the Supreme Court would be saying, well, Congress actually passed a law, and that's what Congress does. Now, we know that's not going to happen right now, but the same thing applies here. It's the state legislatures and it's the Congress that pass the laws. It's the courts that only interpret them.
Right. Yeah. And, you know, I think with the overturning of Roe, I think this specific lawsuit with the Department of Justice, how do you think that it's going to end up playing out? Because obviously, you know, from a legal perspective, you lay out the case that there is merit to the decision. I know there's a lot of lawyers saying that the decision doesn't have as much merit. So there seems to be on both sides disagreement about if this lawsuit is going to succeed or if it's not going to succeed. Do you have any predictions?
Well, again, it's not to upset anyone here one way or the other, but, you know, from a strict legal perspective, I think Garland was very careful to say, one, it's for those places that accept federal funds, which gives it federal jurisdiction to begin with. And secondly, we're narrowly tailoring this so that it's only dealing with people that have serious health risks by continuing the pregnancy. He was very clear to say that preeclampsia or a fetus that is already miscarried, you don't have to wait to the point of death, that the health of the woman is in jeopardy, that it should not be criminalized. So I think he was very careful to make it very narrow. I think, you know, from a legal perspective solely, I think that it's certainly a formidable argument.
Interesting. Bob Bianchi from Law and Crime Network. Great to have you on the program. I really enjoyed the discussion.
Thanks, Addison.